SJC-12484, Commonwealth v. Mark J. Davis.
Ms. Miles, good morning, good afternoon.
Good afternoon. Good afternoon, Chief Justice and Associate Justices. My name is Mary C. Miles. I represent the appellant, Mark J. Davis. If you wouldn't mind, I'd like to first address your request for amicus and the question put before me and the parties. I would argue that in this case, based on the trooper's observations, that he did not have probable cause that Mr. Davis was operating a vehicle under the influence of marijuana. And then an alternative, I would argue, based on the trooper's scant observations, he certainly was not reasonable to deem the passengers unable to drive at the request of Mr. Davis.
What would happen if on the same facts it was not marijuana but it was alcohol? Putting aside and supposing, no formal field sobriety test, just based on observations.
I think that is hit the nail on the head of the difference between alcohol and marijuana and kind of the difficulty we find ourselves in now that consumption of marijuana is legal. Marijuana affects the body differently than alcohol. Alcohol, there are conclusive, it's known within the scientific community that 0.08
Right, but in this circumstance, the police officer made observations about, first of all, we have the motor vehicle infraction, but he also made observations about appearance and demeanor and speech pattern. And I'm just suggesting, if that were alcohol and not marijuana, would that not be enough to conclude impairment? The observations that were made, even though they're not exactly the same as alcohol.
No, I agree. I think the impairment of alcohol generally makes drivers go faster. They are a little bit more careless in their driving as opposed to marijuana, where studies have shown they tend to be more reserved. They try to contain their quote-unquote impairment. They drive slower and they follow farther back. So I would say in regards to Mr. Davis, his speeding and perhaps his tailgating could be a factor in the indication of whether or not he was impaired. The fact that in this case...
miles an hour, wasn't he?
Correct. He was going 70 miles an hour and a 55 for a little while, and then for a short time in a 30 in that, which everyone here knows, that straightaway stretch between exit 18 and 17 and 18 and 90. I think even the trooper himself admitted at the motion to suppress hearing that many people speed. You probably included on that short little stretch. And then in regards to his admission,
And could be stopped by a trooper for it, too.
You have.
No. Let's focus on Mr. Davis if we can.
Take the fifth. Just so I can focus on the argument, and I'm anxious to hear about this, but just so that we have sort of a background of what we're listening to. It was a not guilty on the operating under the influence of drugs.
Correct.
If the theory for constitutional justification to ultimately get into the glove box was that it was an inventory search, whether or not was enough for impairment or probable cause as to the driver just doesn't matter for the analysis. The issue is the passengers because they weren't allowed to drive.
Correct.
Yeah, so, I mean, we can still talk about the driver,
No.
but it's not going to matter for the analysis.
Sure. Okay. So for the.
I mean, it's a question, not an
I'm going
answer.
to stop you there. Without
I think if there
probable
was-
cause to arrest,
If there's no probable cause to arrest, then there's no reason to ask passengers whether or not they're valid to drive.
But
or-
if there's, yes, true enough, but absolutely. But if it's an inventory search, it's the constitutional justification, and the passengers, there's not enough for say passengers can't drive, then that's it.
So you're saying that if there was probable cause for OUI for the driver, but that the trooper's assumption that the passengers were too inebriated or too high to drive, that if that was unreasonable assumption, then the analysis stops. Is that your
Right.
question?
Yeah, because-
Yes, that's correct. I
Okay.
would, that's what I would argue, 100%, yes.
Okay, but please, go ahead, because obviously the chief is right. If there's no probable cause initially, then that analysis stops as well.
Correct.
Let me focus you on our Gearhart decision, where we said that the field sobriety tests aren't validated on marijuana, as they certainly are, or made for, with respect to alcohol. But we did say that a police officer, the value of a field sobriety, and we don't call them tests, but field sobriety, these observations, is that a police officer can see how someone interacts, their reactions, their delayed responses, et cetera. And that's what this police officer did here. He made particular observations about the attentiveness and the like. Isn't that enough on a Gearhart?
I would argue no. I would argue that under Gearhart, we are talking about, your honors were talking about whether or not the officer could opine that based on the failure of field sobriety tests, that there was some scientific conclusion that he is, the failure equates to some sort of impairment via marijuana. And I think your honors were focusing on the fact that marijuana impairment is not as cut and dry as necessarily alcohol impairment, and the field sobriety tests don't measure as accurately for marijuana
but we-
impairment as alcohol. I guess I'm...
Right, but what we said in that case is that the reason why we're going to allow evidence in of how the person did on these tests is because it informs an officer's opinion about how the person was at the scene of the crime, right? When they were stopped by the police. And we're gonna certainly allow evidence in that the person stumbled to get their license, that you asked them for their registration, and there's a 10-second delay like that. So it's relevant to probable cause, and you'd agree with that?
I would say it would be relevant in terms of probable cause if the trooper asked other questions and additionally. I think he basically found that they were just sleepy and smoked marijuana earlier, but the trooper never asked.
But did he say that he was not communicative, there was an attention deficit, I recall reading there was a number of things that the police officer said about the person's behavior, which would lead to probable cause.
So it was my recollection that Mr. Davis answered all questions coherently, understood the trooper's questions. When they asked to search his trunk, he said no. He could produce his license and registration, all without any problem. He exited the vehicle, no issue. I think he said that, at least according to my notes on page 28 of the motion transcripts, he had red, droopy, glassy eyes, dry spit on his mouth, tongue was dry, licking his lips, and his speech was slow and lethargic. So I would argue that unless you're aware of Mr. Davis's, chronic marijuana use, when they smoked, whatnot, you're not really quite sure about whether or not he's impaired. And I would say the fact that he was speeding and the fact that he was following too closely, I would say, given the research into what the indicators are for marijuana impairment, I would say would go against the troopers.
How about the fact that he was reeking, the car reeked of marijuana?
I think that if we were to hold that the car reeked...
One of the factors. It's not, you don't look at these things in isolation, you look at them together.
Correct. I think it's coming from the persons as well as the vehicle.
Yes.
Afterwards, after everyone got out of the car, that they found that there was marijuana leaves strewn on the floor. I think that would be indicative that at some point they smoked marijuana, but we're not sure when they smoked marijuana.
But if we had a drunk driving case and the police officer testified that they rolled down the windows and it smelled like a brewery, there's beer, I could smell beer, we would say, well, geez, they probably were drinking beer in the vehicle. If they roll down the windows and it reeks of marijuana, isn't the same inference valid that, geez, they were smoking marijuana recently in the vehicle?
I would say that then that would sort of, in my eyes, would create a zero-tolerance policy in consuming marijuana driving. There was no zero-tolerance policy in consuming alcohol and driving. I believe there's...
Right, it just goes to whether or not there was a consumption of an intoxicating substance at a particular time.
Correct. That doesn't go to whether or not that substance that they at some point ingested...
Not good for your client, but it's a factor.
That the car smelled like marijuana?
Right.
Correct, but that just shows that at some point they smelled that some point they smoked marijuana or they had a negligible amount of marijuana in their vehicle. That doesn't necessarily give them probable cause to say that he is operating under the influence of marijuana. And
Would there have been anything what would have been enough for the police to, in your view, for the police to have said, you know what, I'm going to have to take you in?
I think if he had asked a DRE agent or a DRE agent came, I think if he had asked, based on the DRE manual and what, the indicators of impairment are, was he a chronic marijuana user? How long ago did they smoke? Did they smoke 30 minutes ago? Then the level of peakness and impairment affects marijuana is highest. Did they smoke 3 hours ago? At that point, while the car might still smell like marijuana, the effects of marijuana have gone down. And those are the kind of questions that I think a DRE agent would ask, that I think would be imperative for a trooper to ask who is not qualified as an expert or not a DRE agent to assess whether someone is under the influence of marijuana.
So in the meantime, since we don't have the DRE agent, the police are supposed to let somebody who's been speeding and following too closely and reeks of marijuana just go on his way.
No, I'm saying that he should have done a better investigation. There were no field sobriety tests done whatsoever, so you don't have anything in our notes. And I'm not saying just as Gerhardt said, it was hard and fast rule that you fail them, you're inebriated, but there was none done in this case. There was no HGN test, there was nothing done. There was no questions or investigation done into when he consumed the marijuana, how potent was it? Do you consume marijuana 5 times a day, or is this the first time smoking marijuana? Any of that inquiry wasn't done in this case.
But your argument is that the field sobrieties and the HGN are invalid. So you're faulting the police for doing tests that are
Well, just to do
invalid.
some sort of investigation to see what is his coordination.
But as Justice Bud asked you, if there was no probable cause to arrest, the person has to go on their way, don't they?
No, you don't have to. I mean, the exit order of the vehicle was proper. I'm just saying he could have said, just like you do in an alcohol situation, well, would you mind taking a field sobriety test? Can I do a couple of tests just to test her impairment? And if through the observations of him during these tests, he finds that, his coordination really is off, and he is really slow, and he's, has diverted attention, his reaction time is slow, then perhaps there would be more facts upon the record that we could assume there was probable cause. Here, the facts that we have on the record is that the behavior he exhibited was contrary to marijuana impairment.
Whatever the record might be, as it relates to this driver, the record as it relates to the passengers is dramatically less.
Correct.
And that, considering the verdict in this case, is much more important, isn't it?
I would argue yes. I would argue that it is easier to make a more concrete decision as to whether or not the passengers were inebriated than it would be with the driver.
Just saying, the evidence that the passengers were not impaired is a lot stronger. You have very few observations of the passengers.
Correct.
And the main thing you don't have is that he's not driving 85 miles an hour too close to the car in front of him, but there's a lot of other ones as well.
Correct. I mean, the only observations the trooper made of the passengers were they were sleepy, and they looked like they had been around the block, and they weren't coming from church, and he just knew they were high.
Right. So now we've got a problem in this case, and maybe you can help us. And that's that the BMC judge didn't finish the findings.
Correct.
Okay, so now we've got to figure out, it's really important to understand the sequence here. Because as I understand it, it's no part of the findings involve details of the search at the police station, right?
Correct.
Nor
Or at the highway.
or at the highway, or anything about the canines and when the canines get involved. Is that correct? So can you walk me through the sequence that we have? Because what we have here is two possible, I don't understand the search incident to arrest argument, but what we have is an inventory search and maybe a MOTA search. But I'm not quite understanding the sequence since it wasn't finished.
Correct. So I believe...
What do we do with that? What do we do with that?
I think you take Trooper Risting's testimony that the judge found was credible, and like I did in my brief in the italics, add to the the judge's findings. I don't think that neither hurts nor helps, or probably actually helps my client's case more than anything. The way I see the facts is they were pulled over. Trooper Ristine took the driver out of the vehicle, brought him to the back. They weren't going to arrest him or do anything with the passengers until another trooper arrived. The other trooper arrived. Trooper Ristine then spoke with the passengers, decided that they were too inebriated to drive, especially after Mr. Davis had asked that the passengers take the vehicle. And then when they then asked to search the trunk.
Okay, but right there, if they weren't too inebriated to drive.
Correct.
And there's not enough information, well, we got Commonwealth versus Torres. If there's nothing left at that point, or is there?
What do you mean there's nothing left in the findings or in the record?
What happens at a certain point in time? The decision is that we're going to do an inventory search. Is that right?
Correct.
Okay, and that's the reason given for the search, at least in the judge's decision. Is that right?
Correct. That was for the search of the trunk and the glove compartment.
Okay.
Correct.
And they find the gun way before they get into the glove compartment.
Correct.
Okay, so if the inventory search is the only constitutional justification at that time, and if there was no information that would have prevented the passengers from driving, then how does the search continue to?
It doesn't.
Okay.
The passengers are not in, the findings, the trooper's findings are unreasonable, or insufficient to find that the passengers are too inebriated to drive. The search ends, the trooper gives the vehicle back to the passengers, and the passengers leave, and I suppose they arrest my client for OUI marijuana.
Well, there's evidence, right? Major Ristine stated the passengers looked high, their eyes were red, they had their heads tilted back with eyes closing, it appeared to be sleepy. There's marijuana strewn about the car, right, too?
So that was found after the passengers, everybody was taken out of the car.
Okay, all right.
What is the, just two fast questions because you're over your time.
Yes,
What
I'm
is
sorry.
it's not your fault. What is the standard that we apply when the police officer has to decide whether the passengers are unfit to drive?
There has been no specific standard. I only find that the passengers have to have a valid license, have to have authorization from the owner, and in the officer's reasonable judgment at the time. I would say in this case, there needs to, when dealing with marijuana, there needs to be some sort of investigation as to what they smoked, when they smoked, how much they've smoked, and perhaps maybe some, if this court, finds some field sobriety tests that work with marijuana, that would be sufficient.
So our standard is whether or not the police officer exercised reasonable judgment in deciding that he should not let them drive.
Correct.
Chief, can I ask one more question? Okay, thank you. So if it is an inventory search, and I think the Commonwealth is going to ultimately argue that it's a modest search, and this time sequence is really going to matter, and we're missing findings from the judge. But if it is an inventory search, at some point, you can't get into the glove compartment on an inventory search in this case because you've got canines doing an investigatory search.
Correct.
So the inventory search, which is the reason for the judge's findings, cannot be the grounds of constitutional justification to get into the glove compartment because the canines are involved and it becomes investigatory. Is that your position?
I would argue yes, and the Commonwealth argued in their brief that the canine didn't find anything, and I would argue that's contrary to the record, where all the troopers' testimony at trial was that it was Trooper Blackwell and his canine who were a solo in searching the vehicle, and then Trooper Blackwell found the narcotics in the glove compartment. While there was no specific testimony that says the canine alerted, we opened it and took it out, I would say the reasonable inference is that Trooper Blackwell and his canine found it. I would also...
Either way, there's no findings from the judge on that issue.
None.
Okay, thank you.
Thank you, Your Honor.
Ms. Campbell?
Good afternoon. May it please the court, Kaylin Campbell on behalf of the Commonwealth. I'll start with Justice Louie's questions about what the record is about the passengers that were in the back seat, and that can be found, the judge's specific findings, on the defendant's record appendix, page 69.
Judge's specific findings?
Excuse me, Your Honor?
The judge's specific findings?
Correct.
The judge said the passengers appeared to be under the influence as well. They both readily admitted to smoking marijuana. Major Ristine stated the passengers looked high, their eyes were red, they had their heads tilted back with eyes closing and appeared to be sleepy.
Correct.
That's it, that's all.
I think you don't need any more.
It's not very much.
I disagree with that. You have individuals who have readily admitted that they had been smoking marijuana.
They were driving from New York, that could have been 4 hours ago.
And I disagree that there's not testimony in the record as to how recently. I would say that the fact that there is the smell of burnt marijuana in the car supports that it is more recent than 4 hours
Why?
ago.
Marijuana smells over a long time, don't you think?
No.
No? You think it disappears right away?
I think it can I don't think that it's something that can go away. I think that it's burnt as opposed to unburnt is important.
Somebody was smoking, yes, they admitted they smoked, but the question is when they smoked.
Correct, and I think also you have to look at what the observations are of a major of the state police who specifically testified that he had 30 years of experience and that he had made 50 specific arrests for OUI marijuana. And in his experience, the behavior that they exhibited, coupled with the emissions, coupled with the odor, coupled with the marijuana strewn on the floor, supported that they weren't in a state to drive. I'd say that absolutely should be enough. There's a reasonable objective basis for the officer to believe that these passengers should not be entrusted with driving a motor vehicle, not just on any road, but on the Mass Pike. So a highway in which you're asked to drive with a number of other people at a high rate of speed.
Your sister says the standard is reasonable judgment. You say reasonable objective basis?
I would agree.
Because we've said so, or this is because you're just clever?
I would admit that I am clever, but I don't believe there's any case law which has said so.
So this is the case for us to establish what that standard is.
Correct. For support of why I said what I did, I would look at it just as you look at most other decisions that officers make when they're faced with them, and you look at the objective basis and the specific facts by which they draw the conclusions that they draw.
But it's not probable cause.
I don't think it would have to rise to the level of probable cause.
And in terms of doing that, does the police officer have the same ability to make an investigation as the police officer would of the driver? That is it appropriate to say, I'm going to ask each of the passengers to do a field sobriety test when they're the passengers and not the driver?
I hadn't considered that question. I think it would depend on the facts that are presented to the officer. If there is no objective basis to conclude that a passenger would be impaired. For example, in this instance, let's just say that the individuals, there's no smell of marijuana, there's no admission that they had been smoking marijuana, they just look tired, then maybe that wouldn't be reasonable in the circumstances. I think where you have an objective basis to believe that they may be impaired via some sort of, for some reason, that there should be a duty for the officer to have a basis to make that conclusion.
Suppose they were just tired. Suppose they were just really exhausted. They'd been up 24 hours and you could tell how tired and punchy they were. Couldn't, on grounds of public safety, the officer decide you shouldn't drive?
Yes. I think that would be entirely reasonable because you're asking, I think the question was posed, and I think it was Justice Blood, what are the officers supposed to do? Or you're supposed to hand over a car to someone who doesn't appear as if they're in a position that they could drive it safely?
What's that civil case, Weir? Isn't that the case when the
Right.
police let the
Right,
person
right.
go? And, and someone can get killed. Someone
Correct.
did in that situation, in the
Someone
Weir
did-
case.
Correct. And someone not so recently, I think it was in Cambridge, the same thing happened. A person was stopped, they were allowed to go, happened to be high, and they killed somebody. I don't think that the officers should have to take that risk. I would also disagree as to any assertion that the officer here did not have probable cause to believe that the driver himself was under the influence of marijuana and that was affecting his driving. I think there are 10 specific facts, which I'll highlight, but I think where it starts is Major Ristian's observations of the defendant driving, specifically not only the speeding, but the tailgating. And Major Ristian specifically testified that in his experience, when people consume marijuana, it affects their ability to perceive
depth perception, so that's what his attention was drawn to, the tailgating, because marijuana affects depth perception. But he has the smell of burnt marijuana, both from the defendant's body and the car. 2, that the defendant had droopy, glassy eyes. 3, that he had dry spit on the sides of his mouth. 4, that he had a dry tongue, appeared to have a dry tongue. 5, that he was licking his lips. 6, and I think this is important because it goes to the investigation. My sister faults Major Ristein's investigation, but I think he took a number of investigative steps in this case. And he specifically said that in his experience, field sobriety tests aren't a good indicator for impairment of marijuana. So what he did was he asked this driver to get out of the car, and he wanted to engage in a conversation with him to see both his reaction time and whether there was a problem with his coordination. When doing this, he noticed that the defendant, and this is the 6th factor, had slow speech and he appeared lethargic. 7, that he had slow coordination in his movements. And 8, that he had difficulty focusing on the questions that the trooper was asking him, the major was asking him. Specifically, that the major had to tell him 4 separate times to keep his hands out of his pockets. Also, during this conversation, the defendant's head was bowed down. And the 10th is that the defendant had admitted that he had smoked marijuana. Now, while it was hours before, there is an admission that he had ingested the substance. I'd say all of those factors give rise to probable cause, which is probably...
And does his level of, inebriation, or whatever the proper term is with drugs, affect our analysis of the others? The fact that he's that high, does that also provide some support for the others maybe have been sharing the same stuff, and maybe, is there any relevance to that?
I believe so. I think it's one of the totality of factors that that an officer could consider in concluding that the passengers were also
The thing I'm
impaired.
worried about from your perspective is the canine search. Just, it seems out of place here. So what do we make of the canine search?
And I think part of the problem, and Justice Lowy, you hit it right on the head, is that there aren't findings about the canine search. And so while the testimony is credited by the officer, by the judge, she credits Major Ristein's testimony and the testimony of the other troopers who testified. I don't necessarily think that it's so uncontroverted or clear, which doesn't help my position much standing in front of you, but if it is dispositive in this case, I think a remand would be appropriate, so there would be factual findings.
Okay, so if there were a remand, or if somehow, even though there's no findings, we can do something here. To explain to me, I know there's no findings on this.
Correct.
How is it that the police can get into the glove compartment? It can't be an inventory search if the canines are involved looking, trying to alert.
I think that's where the timing of the canines
Exactly, I need to know the sequence, and then we don't have findings.
We not only have findings, I don't think that the testimony from the major is, at least to me, I also have been trying to figure out the sequence of the canines.
Yeah.
And it comes out during cross, and even on cross, it's unclear at which point in time the major calls to have the canine come. I read the transcript again today, and it's a question that's asked, and then on cross-examination.
But the canine certainly doesn't come after they find the marijuana, right?
It doesn't.
Okay,
And-
so how do we make it how is it an inventory search to protect personal property when you have a canine rummaging through a car looking for evidence?
I don't even think we can say, on this record, I don't think we can go so far as to say the canine rummaged through the car to find evidence.
What
Because
was the canine doing then? Why did he call?
well, there are different ways that a canine could do a search. It could be an outdoor.
This is a situation where they have the vehicle towed.
Correct.
It's in the barracks. This major says, get me a canine. A canine shows up, and it's an inventory search?
Well, I'll say before, so here's where I think here's where I think it matters, because before any of that happens, what you have is a car that's in the middle of Mass Pike, a driver who's going to be arrested, and no one who can drive the car.
Okay, I'll give you all that. All right.
And so at that point, but I think it's important because at that point, the trooper, pursuant to Massachusetts State Police policy, has to inventory the car because, And so the inventory search starts at that point. It's that point that they get into the trunk, they find the gun. I think all of that is okay. And I think it's okay that they go back to the barracks because as the testimony is, they're backing up traffic, they're 60 feet in front of a toll booth. And that's where I think the timing as to specifically what happens, the parameters of the canine search, when specifically it was called, I do think that that is important.
So you think it's possible that it starts out as an inventory search and then turns into a search for contraband at some point?
Well, I think not only is it possible, if you look at the specific terms of the inventory.
But isn't it the government's burden in this instance?
It is, and I think we met it in terms of the inventory search, is that once you start an inventory, you have to finish it. You can't just not complete the inventory of the car.
Can you have two different kinds of searches going on at the same time?
I believe so. My view of the inventory search line of cases, it's where you don't have probable cause and you don't have any other justification which would get you into the car.
Yeah, so Ms. Campbell, I guess this is what I want to ask about MATA then. Because I have the same concern that Justice Gaziano raised, which is I have a hard time having a canine and an inventory search at the same time and say it's an inventory search when we have a canine involved. So is there probable cause from what happened, separate and distinct from an inventory search, with the findings we have from the judge, that there's probable cause that there's evidence of a crime in the car? Is there a MATA search?
There could be, so
With the sequence we have.
with the sequence
Sorry
that we
to
have.
put that in, but we have to.
No, and I understand, and I wish that, it would be much easier if the testimony was uncontroverted and there were better findings, obviously. You have
Does that mean we should remand this to clarify this?
to the extent that it would be dispositive, yes, I believe so.
But what do we do? You're saying that once you bring it in to the police, then the regs say, police regs say, now you must inventory it.
Correct.
But and then we have at least somebody who says, I'm going to send the canine around to see if we have drugs, which would be generally investigative.
Correct.
So, and yet an inventory, we need, this is one of the few searches in which we need to look at the subjective purpose of the search, which can't be investigative in purpose.
Correct. But part of the problem is if the inventory search is valid at its inception, which it is here, and the policy doesn't give the police the ability to not complete the inventory search, at its base, that should be a proper inventory search because it would.
That would be a big loophole, wouldn't it, for an investigative search to, any time police wanted to do an investigative search, they would just start with an inventory search?
No, because it has to be a proper inventory search at its inception.
No, I'll give you that.
Yeah.
So proper inventory search, but gee, let's see what else we can find.
Unless we think the true purpose of the search was not an inventory, as evidenced by the call for the canine, then you're out of luck.
No, I don't think I'm out of luck, because I think, as I argue in my brief, there's still independent PC to believe that the driver was engaged in a crime.
This is the motor vehicle exception.
Correct.
You want us to look at that.
Correct.
But so you have this curious situation in which you could have a police officer who says, I've got to go by the rules, and the rules say I need to inventory. And then there's another police officer who says, I want to conduct an investigative inquiry, and I want to send the canine around. So you have two different officers, both in the same force. One may have an investigative purpose, the other may have a pure impoundment purpose. What do we do?
I think then you look at, I think what you do is you look at the basis, was it reasonable, right? And it falls.
But it's not reasonableness, it's in purpose. I mean,
But if it's not quite, but it's almost like inevitable discovery. If this inventory search in total would have been permissible, and this evidence would have been found via this inventory search, then I don't understand what the basis of suppression would be.
Would it be different if if the dog's alerted to a panel in the door, and so they took apart the door and found the contraband there?
Correct. Because at that point, it wouldn't be, in your hypothetical, it wouldn't be an area that necessarily would have been searched pursuant to the inventory policy.
Yeah, and these are all important and fascinating possibilities,
Correct.
but we don't know the sequence.
And I'm forced to.
It's not your fault, but we don't know the sequence. It's not your fault, but we don't know it.
Yes, I mean, I have the same problem that you do, and I wish I could say that the evidence was uncontroverted, but I would say to the extent that I come up and point to transcript sites that are different than the transcript sites that my sister points to and says this is the sequence, then it's not an uncontroverted set of facts, so it probably should be appropriately sent back for a remand.
Would
But-
there need to be more evidence taken?
I think that yes, because there is a dearth of evidence about the canine search generally. It's just that it happened. That's an interesting question.
But if there is no right to be searching the car after the arrest, and it's an inventory, at least until probable cause develops during the inventory, if that's the case, but inventory is what lengthens out the investigation, and if the passengers should have been able to drive, one of them been able to drive away, then the curtain comes down and the sequence after doesn't matter. I understand that you say that they couldn't drive, and that might well be right.
Correct.
But if one of them could have driven and you don't have PC yet, then the curtain comes down and you can't continue the investigation.
Well, PC for what?
Well, that's the question. There's no,
not
I mean, that's the question. It's, because ultimately, how is the gun is found during the inventory part of this?
But the gun is found at the inventory on the scene. And so I think it is clear from the testimony that what happens is there's a decision that the defendant is going to be arrested for OUI drugs. He's taken out of the car. Defendant asks, and this is Major Ristein's testimony, defendant asked that one of the passengers be able to drive the car. Major Ristein says no because they're impaired. The passengers then ask if they can retrieve certain belongings from the trunk. They open the trunk, permit the passengers to take the belongings, and it's at that point that they inventory the trunk, that they start the inventory search into that area.
Okay, thank you.
Thank you.
We done?